Welcome back. The COVID-19 pandemic has certainly had devastating health and economic impact across many in this nation. Recently, Governor Andrew M. Cuomo signed an executive order extending the state's moratorium on COVID-related commercial evictions and foreclosures through January the 1st. The measure also extends protections already in place for commercial tenants and mortgagors in recognition of the financial toll the pandemic has taken on business owners, including retail establishments as well as restaurants. Joining us now to share a little bit more about the discussion, including this recent extension, we are pleased to have joining us the partner at David A. Gallo and Associates, Robert Link, and we're glad to have Robert Link with us. And Robert, good to have you.
Thanks, Darren. Great to be here. Thank you again for having me.
Oh, thank you. It seems like every time we talk, the governor seems to be making some sort of new push or new extension. But give us a little bit about this here. We've got January 1st. This new extension is in place. Let's talk to about what this actually means for as tenants as well as landlords.
Okay, what the extension means is if you have a COVID hardship and the landlord wants to bring a non-payment eviction where you haven't defaulted on your landlord-tenant rental payments, they have to wait until the end of the year in order to do that. In fact, there's legislation that says, that's been passed and approved by the governor, that says even when they bring that non-payment proceeding, the landlord is able to seek the money due, but they're not able to evict you if you're able to prove that you have a COVID-related hardship. Now, even though there are these protections, and there's federal protections that say non-payment proceedings for those of us who are facing COVID hardships is going to be, there's going to be a reprieve until the end of the year. Notwithstanding that, holdovers can be brought right now. So you can bring a holdover eviction. And what that means is if you don't have a lease, or if you had a month-to-month lease, and your landlord decided to terminate that month-to-month lease, they can actually proceed with the eviction process. Now, even though they can technically, under the executive order and under the CDC guidance, and under the statutory relief that's been passed by lawmakers in Albany, even though they can proceed with those holdovers, nothing is really moving forward at this point. The court is moving very slow at a snail's pace to deal with the evictions that it was dealing with back before March 17th happened, before we had the COVID pandemic, for those who their lease expired or they weren't making rental payments before March 17th. And because the courts are really busy right now dealing with those cases where you have landlord harassment or landlords taking actions where they're removing possessions without authority of a sheriff. So you have the courts tied up with those cases. They have to deal with these cases in a socially distant way. So you're not going to see those new holdover cases, particularly in the city of New York, being dealt with until February, until March, until April. And we're really, in my opinion, as long as you're answering your holdover petition, as long as you're responding and raising the relevant defenses, I really don't see this thing picking up until May or June of next year.
So honestly, if I'm a landlord, I really can potentially be in trouble financially, given the fact that you're saying the older priority is going to be given to cases that actually took place beforehand. So now to deal with this in the after COVID, you're going to be second priority, if you will. So for a landlord, it may be tough to actually survive.
The small-time landlords are in some trouble. And the best thing you can do, and I represent some landlords, is to give them, reach out to your tenant and try to come to an amicable solution where the tenant is paying what they can. I just resolved a case up in Harlem where the tenant was paying, I'd say, about 60% of her rental income. The landlord wasn't happy with that, but I convinced the landlord, listen, 60 cents is more than half a loaf, and right now that's probably the best you're going to get. So what we did in that situation is we said, let's revisit where we stand in, I think it was June of next year, and we'll take a reprieve. We'll accept 60 cents of the dollar without any prejudice to anyone's rights under the lease. And then we'll revisit the situation in June. We'll look at what the relevant rents are in the area, and we'll come to an agreement. I've been encouraging most of my landlord clients to do something similar. If you're a tenant, that's also a good thing, as long as you're paying an amount that you can afford, but you want to be careful about agreeing to a long-term agreement that maybe works for you now, but doesn't work for you 3, 4, 5 months from now. Don't agree to something because you feel like you're under the barrel of a gun, because quite frankly, if you're a tenant, you're not. You have plenty of time to make an arrangement and appear in court and exercise your rights. You just have to make sure and show up in court, respond, or if you don't feel like going to court, call the number at the court helpline and make an arrangement to have a postponement or appear via Zoom or whatever conference call to handle your defenses and conferencing that way.
Do we see this being even more played out, given the fact that here we are in New York City talking about a potential second wave, and with a potential second wave, of course, there are going to be more closures. Of course, there's going to be more safeguards in place. And so this whole thing, as you say, possibly June for commercial, but this whole thing could actually be playing out for possibly another year or even years possibly to come.
Sure. I think you will see, Darren, to answer that question, you're going to see litigation for years. Appeals take years to sometimes play out in our state court system. And we have this guidance, administrative orders, executive orders, there's new laws. And a lot of times we're not going to know what these laws mean because the language is somewhat contradictory or not 100% clear. It's not going to be clear what the language means until we see all this play out. So it's going to be interesting to see tenants raise these defenses, mid next year, and then we'll start to have a better idea as the year progresses. But you're seeing with this postponements to December and beyond, really responding to the concern you raised. We don't want to just start, 100% going back into court, having full calendars and having full courtrooms, because at the end of the day, we don't know if there's going to be a second wave, and we don't want to have to shut everything down 100% again. So we're creaking the door open little by little to start to deal with cases in a way that respects everybody's rights to the best that they can. And then towards the end of the year, we'll reassess the situation and determine if there needs to be a further extension of the moratorium. You're going to see a lot of landlords bring holdover evictions as opposed to non-payment evictions, because the easier thing to prove in certain circumstances is, well, this person doesn't have a lease, as opposed to this person didn't comply with the terms of the lease. So you might see a lot of that next year, where the landlords are bringing holdovers as opposed to non-payments.
Yeah, we talked a lot about commercial. I only have a couple of seconds left to talk about residential. But when we look at residential, a lot of the same things will probably happen, huh?
Oh, yeah, definitely. What I'm saying about commercial also applies to residential. We're barely getting started in the residential context. You're having some cases, particularly where there's some sort of emergency circumstance, the court, escalating those matters. But by and large, new cases are being adjourned into March, into April and beyond. That's when I think the first cases, the cases that were brought in 2020 that are after the pandemic period, that's when I think we're going to start to first see those cases. And then if those renters are interposing an answer to the complaint, to the petition, then there'll be a date scheduled for a trial, or there might be some actual discovery if it's a non-payment. Because remember, there's the Tenant Safe Harbor Act. So if you're in default on your lease and you're not paying your lease because you've had a reduction in income, the New York State Legislature and Governor Cuomo have said that that is an affirmative defense to your eviction. It doesn't mean you don't have to pay your rent you still owe the money technically, and you could, I guess, file a bankruptcy and deal with that issue, but they cannot evict you on that basis alone. But that is something that has to be raised in your answer to the petition. So if you qualify for a free attorney, that's something that you want to take advantage of. Also at the courts, if you go down to the courts, if you call the numbers, there's information on downloading a pro se answer, or you can hire an attorney or appear by yourself. The most important thing is to be familiar with these laws and how they apply to you, and take advantage of them.
All righty. Robert M. Link, we're going to have to leave it there. Attorney Robert M. Link, and we want to thank you for being with us here on Open, giving us some much needed information for a time such as this. Thanks a lot, Robert.
Darren, anytime. Thank you.
All right. We got more Open. We want you to stay with us. More show coming up right after this.